With respect, Mr. Justice Iacobucci, the constitutional support for a penal sanction, in my respectful submission, is irrelevant to the standard by which the constitutionality of the exercise of that power by a parliament or legislature is to be gauged. I think it was several months ago when I was before this court on the tax cases Jarvis and Ling, and there was a debate as to whether tax evasion falls under the criminal law head of power or under the tax head of power. And ultimately, this court, I think, said it didn't matter. And as I recall, counsel for one of the two appellants said, quite correctly, from his client's perspective, jail is jail. So the liberty interest
well, yeah,
is
but
the same.
no, let's not be so quick with that, because in wholesale travel, we did draw a distinction between regulatory. Let's not be just forgetting about that. We did say, and the critics of the case can say, well, what's the difference? You're going into jail, and it's no solace to say you're in jail for a regulatory offense as opposed for a criminal offense. But the point here is that you don't get, there's a criminal record that's attached to the criminal offense. There are other consequences that flow from criminal conduct in our society, as opposed to I'm not saying the others are not serious or that they're unimportant.
Well, there may be, in certain circumstances, criminal records that attach to regulatory offenses. I come back to Mr. Fitzpatrick. Right? Under the Identification of Criminals Act, fingerprints can be taken with respect to a hybrid offense. In Mr. Fitzpatrick's case, and I don't know if this actually happened, but with hybrid offenses, regulatory offenses that are hybrid, a person can be fingerprinted. If convicted by indictment, he or she may have a criminal record. There may be a record that says convicted of this particular offense. So I say with the greatest of respect, Mr. Justice Iacobucci, the court ought not to develop the constitutional yardstick for measuring whether Parliament or a legislature has properly provided for incarceration in respect of an offense which is within its jurisdiction to create, by setting up a system of different yardsticks depending perhaps on the constitutional head of power or raison d'etre for the particular provision. This court said in the Motor Vehicle Act reference, which was a motor vehicle case, that once the liberty interest is engaged, the charter is engaged. It should be no different, in my submission, between the Controlled Drugs and Substances Act, the Criminal Code, the Income Tax Act, the Highway Traffic Act in Ontario. If there is provision made for incarceration, there should be one yardstick and one yardstick only that's used as a measure against whether the decision by the elected representatives of the people to pass that legislation will be ruled unconstitutional. Courts are, in my submission, not possessed of the institutional structure and competence to engage in what amounts to a commission of inquiry or a parliamentary committee. In these cases, some experts were called, admittedly, but certainly the trial judges in these cases didn't have the same volume of information as certain royal commissions have had, perhaps didn't have the same volume of information that the Senate and House committees had. So there are constraints on the ability of courts to deal with harm in the manner suggested by those opposite me.
In the context, for instance, of an attack on this kind of legislation based on a division of power argument, assume for the time being that we don't look at peace, order, and good government. If the federal government was putting forward its legislative authority over the prohibition of possession of marijuana on the basis of its criminal law power, in the same way as in the prohibition of the handling of firearms and so on, the courts would have to decide whether there is a valid exercise of federal power. And part of that exercise would be to search for a genuine sort of public evil or a form of harm that would justify the self-standing jurisdictional authority of the federal government. In that context, even before we get to Section 7, they are constitutional constraints that don't fall within a kind of, well, the jury's still out as to whether there is harm or not. So at least for that purpose, it would seem to me it's perfectly within the ambit of what the courts have to do to determine whether there's a valid exercise of the federal criminal law power. Separately from that, and in the case of the federal government, presumably additionally, then the question is whether there are constitutional constraints on both Parliament and the provinces on the use of imprisonment. They can prohibit, they can regulate, they can sanction, and that's why the use that we've made interchangeably of criminalizing or using a penal sanction seems to me needs to be focused a little more on access to imprisonment. Neither the provinces nor the federal government, arguably, can access imprisonment for the enforcement of their laws without any kind of constraints. They have the Section 7 constraints. The BC motor vehicle case is squarely on that. They cannot do it through the imposition of absolute liability.
But, Madam Justice Arbour, I mean, I'm not disputing that, nor can I dispute that. What we're talking about here is at what level of abstraction will the courts review under Section 7? There's no question that Section 7 applies, but what's the standard of review? That's the first thing. Put all of the information as it relates to marijuana or any other substance or criminal or quasi-criminal offense to one side, okay, and decide the test, and then you apply the test to the facts. My learned friends opposite say, well, there's not enough harm. Well, how much harm is enough? Mr. Justice Rosenberg was concerned with that. I mean, although he applied the test articulated by Mr. Justice Braidwood, he saw that there were problems with it. Now, in terms of division of powers, I mean, I addressed that later in the factum, particularly the criminal law powers starting on page 54. But there has to be a valid criminal law purpose. This court has repeatedly said that health concerns are a valid criminal law purpose. It has not, to my knowledge, then gone in and started to dissect the matter to see whether that purpose was valid enough. So again, in my submission, it is a baseline on the concerns that I just read to you from the judgment of Mr. Justice Rosenberg in the Parker case. There's clearly, in my submission, sufficient to warrant the use of the criminal law power. What those opposite me are saying.
But do you draw a distinction between what I would call the division of power analysis and the analysis under Section 7 as to the role of harm, the extent of harm which is required, as to the distinction perhaps between the legitimate criminal law purpose and the rational basis for action under the Charter?
They are different tests. I agree they are different tests, but when one comes to formulate the test under Section 7 of the Charter, in my submission, one cannot divorce from that consideration the fact that we have a well-developed body of law under division of powers that sets out the circumstances under which the legislature can act. What defines the field? That's also part of our Constitution. And what those opposite me are saying, in some cases, is that one part of our Constitution, Section 9127, is by reason of Section 7 removed unless there is a certain level of harm that the Crown can establish. So that level of harm then effectively becomes necessary for the purposes of enacting legislation. So I say that the fact that we are dealing with two parts of the Constitution has to be considered. Right? Certain powers are given to federal and provincial governments or legislatures. The Charter constrains the use of those powers. But in our Western democratic society, the issue here is what is the role of the court in terms of assessing whether a legislature or the Parliament of Canada has validly used one of the powers that it has under another part of the Constitution. My submission is that this is clearly rational legislation. There is a basis for it, both in terms of individual health and societal needs. I don't know, perhaps peanut butter. But the difference, of course, between marijuana, alcohol, to some extent, and tobacco on one side, and peanut butter or perhaps cookies on the other, is that one is a food that's necessary for sustenance. One is the others are substances that people use because they enjoy using them. So it may be that the court would find no rational basis to put somebody in jail for having a peanut butter sandwich. But I'm not here arguing the peanut butter case. I'm here arguing first as to what the test should be, and then laterally applying that test to marijuana.